It is my privilege to introduce the next speaker, and we have for the second talk Joan Porter, who is gonna talk about risks and guidelines. She received her law degree from the University of Houston Law Center and immediately became an attorney for the city of Houston. She then entered into private practice for about 10 years before she joined UT Southwestern as the Assistant Vice Chair for Legal Affairs. And the title of her presentation is, Am I at Risk for Following ACO Guidelines?
Super. Okay, so I handle medical risk issues for UT Southwestern. I have a history as a trial attorney. Currently, I work with our physicians in our institution for those cases of medical malpractice and quality of care concerns. I am the person that no one wants to hear from. So I appreciate and thank you for the opportunity to talk to you today. I looked at this, and in addition to just the disclosure that this doesn't constitute legal advice, in preparing for this, I tried to do some research on the topic. I found that there was research, very little conclusions. And I think this partly is because, first of all, conclusions that come out of law come at a glacial pace. So we've got the ACO guidelines. Things have really sped up in the last 10 years. I don't know that those conclusions that we're going to know how things are affected are going to be apparent for another 10 years. So it's just law is slow, and also the conclusions that come out at how they are effective, what risk they are. Those conclusions come out at the appellate level. Very few cases go to the appeal, and so really it's the battlefield for these is in the trial court and in the actual litigation that you may be involved in, rather than something that is researchable. So my disclosure is that this talk is a little bit like reading the tea leaves based on our experience, what I read, and what may be occurring as we look forward, as these guidelines get to be more and more used. So I'm going to take a minute just to look at what's old and what's new. You know, guidelines they're not new. They've been around for at least 50 years. And they've been kind of a scary thing in a way, because from a legal context, they've often been used to prove that a physician did not follow a guideline and therefore violated the standard of care. But in the past 10 years, there's a marked increase with focus on delivering safer and efficient care. There's been a proliferation of guidelines. Historically, they've been used to show that a physician violated a standard of care. I question whether or not they may be used in the future to show that safe care was delivered, the guideline was followed appropriately. I would say also what one effect guidelines have had, and we're seeing this more as there is more proliferation of them, is that they've changed the law in Texas, really, from the locality rule to standards that apply nationwide. So it used to be that the standard of care for a physician was what a reasonably prudent physician would do in your locality. That changed in Texas in 1987 with a case called Birchville versus Texarkana Memorial Hospital. What happened there was a child was born with an eye condition, congenital. The child was given supplemental oxygen, and after the hospitalization, the child actually became blind. So in evidence, it came out that there was a American Academy of Pediatrics report from 1971. This case was in the mid-'80s, and in which the report linked the use of supplemental oxygen with eye damage and cautioned on the need to have very strict, careful arterial blood gas readings, and this didn't really happen in that hospital. So the law had been, the guide that applies to you is what people in your locality did, but this American Academy of Pediatrics paper came in as evidence, and the court decided, and it was upheld on appeal, that it's what people in your similar circumstances, same or similar circumstances, would do. So you may be a small hospital in Texarkana, but the standard may be a nationwide one that is brought to you. So these guidelines have seriously affected litigation. So you might ask, why and how does any guideline factor in litigation? Why does it even come in? Because actually they're hearsay. Hearsay is an out-of-court statement offered to prove the truth of whatever the statement is. So the guideline is saying you should do this. That's some other person talking. Why would that even come into litigation? And we all know that they have disclaimers on the face of them. Any guideline says this is not meant to tell you how to practice medicine. So why do they even come in? And I think this context of how they historically come in may help us figure out how they may come in the future in a slightly different way. So first of all, an expert can testify that the guideline is part of how the expert makes his decision-making of what an appropriate care standard would be. They can come in, actually, if the physician admits that this guideline provides some kind of authority. So usually if you've ever been deposed in a med mal case, your lawyer will always tell you, never admit that anything is authoritative, because that means it's going to be admitted into evidence. You know, many a physician has had a heel stuck into their shin during a deposition because they forgot that, you know, Williams Obstetrics is not actually authoritative. So they can come in that way. And sometimes a judge can just let them in because maybe they shouldn't come in technically, but the ability to appeal a case based on an evidentiary point is very, very small. And the worst thing about them is, even if they don't come into evidence, they're very useful in beating up the client in mediation, pretrial discussions. They get waved around, and everybody actually feels pretty bad about them at the time. So they've been a little scary to us. You know, ACOG is one of the scarier guidelines, partly because there are a lot of med mal cases involving babies, but much money has changed hands over ACOG guidelines. But I've noticed that they're being revised a lot. Definitions are trying to be tighter, more explanation about the difficulties of predicting something based on fetal heart rate monitoring, etc. So the question now is, do the ACO guidelines provide new challenges? Because they're a little different. First of all, there are more of them, and sometimes they're in conflict. So that, I think, is challenging on its face. And then the real question is, really, if they're made for efficient care, is somebody going to be accused of providing a lower standard of care to save money? Because I know that I hear physicians say, we are charged with, you know, commanding resources, being careful about how we spend, but that just really doesn't work well in front of a jury, particularly if you're the plaintiff who was injured. So I think the question is, do they provide new challenges? Maybe. But I think also that patients and the public are getting much more attuned to the fact that efficient care is better care. And everybody who goes to a doctor now, you know, it's just, I see it in my own visits. The doctor says, we could order this test, but I don't think it's going to make any difference to our decision. So we are curious as human beings. Our tendency is to say, I want to know everything I can know, but I think the public is being educated that that may not be the best thing. Sometimes, so in addition to efficient care being better care, it's backed up by evidence, so it's explainable, and there's a consensus of experts behind it. And remember that you can always argue that your thought process is correct, even though there was a bad outcome. That is something that lawyers argue a lot, and it works. So exceptions, yes, they're still going to be argued. There's going to be hard cases that make difficult law, individuals who are very injured, and it's going to be a harder case, but I think that although they provide challenges, the ACO guidelines also present some benefits. There's been some talk about safe harbors with these. I know the legislation before the U.S. Congress now has some wording in about safe harbors. There have been some cases in the past in different states where they've done some experiments and research projects. If you follow the guidelines, can you actually get immunity, which is like love immunity. It's totally golden. But they haven't really become useful. So the practice on those is safe harbor sounds good, but it doesn't actually help much. However, I do think that they do articulate a good plan of decision making, a process, the evidence base is behind it, and again, there is expert acceptance to support decision making. So in this way, I wonder, can guidelines be used not as a threat over the physician, but actually what we call the defense sword? I followed the guideline. And other people, this is maybe not a standard of care, but it is a thought process that's articulated and makes sense. So I think that helping to explain the thought process to patients is very, very helpful because people are buying onto it. Documentation is going to be important. So lawyers love documentation. I'm not one of those people that thinks if it wasn't documented, it didn't happen. You know, that just isn't correct. But it is important. So some things, what can you do, and how is documentation going to be important? I think it will be. I think it takes on potentially more significance. So was the guideline followed well? I think that's the risk. You can follow a guideline, but if you're not following it well, if the results aren't looked at, things aren't timely, follow-ups don't occur, then I think that's its own problem, and documentation about the thought process will be important. Were timely interventions made? And was the patient instructed on the plan? So all of that, I think, is going to be important. I think that's, I had some questions, and one of them was, here's a question. Dr. Jones followed the department guidelines in the workup of a patient with shortness of breath. The patient wasn't likely to have a PE based on the Wells score. The patient was discharged home but came back to the ER later that evening. A CTA was done and the PE was found, of course. So if the patient decides to seek litigation, where are we going to be? I think this was a Dr. Brewington question. So I had to look up Wells score, first of all, on the internet, and I saw that it was a formula, and I thought, great, I can do this. Of course, as I read, it became more and more complex, and I realized not so easy. So the question is, can you still be sued if you follow this formula? I would say, as in all things in litigation, following that formula or a plan is really strong and powerful, but always the extra information that you give, followed Wells score, did not apply, no other symptoms were apparent. You know, the actual laying eyes on the patient and providing that in the documentation, I think is a powerful defense. Thank you.